April 5, 1933. Washington, D.C. Franklin Roosevelt signs Executive Order 6102. In one move, the government orders Americans to hand over monetary gold, not at a negotiated price, at an official one. Then the rules change again. $20.67 an ounce first, $35 an ounce after the gold is centralized. This is not fiction. This was the United States, 1933. Here is what blows people's minds. Most people think this story is about confiscation, a hard president, a desperate crisis, a one-time seizure. But the forensic record is worse than that, because the deeper event was legal redesign. Franklin Roosevelt's order did not merely reach into private hands and remove metal. It changed the category. Gold coin, bullion, and certificates that had functioned as personal monetary defense were recast as something the state could forbid you to hold, force you to deliver, and settle at a price it controlled. Franklin D. Roosevelt, Executive Order 6102, 1933. And once you see that, the whole episode changes. This was not only about what they took, it was about what they made impossible. If you held gold before April 1933, you held more than a commodity. You held a way to step outside bank insolvency, outside paper promises, outside a failing chain of convertibility. That was the real threat. Not the metal itself, the exit. And the system moved against that exit in stages. First, the banking holiday. Then the prohibition on private monetary gold. Then the destruction of gold clauses in contracts. Then the official repricing after the metal had been centralized. Proclamation 2039, March 6, 1933. Joint Resolution of June 5, 1933. Gold Reserve Act, 1934. Watch the human scale of that break. F. Eugene Nortz held U.S. gold certificates and surrendered them under protest in January 1934. He later went to court. He lost. The Supreme Court held that what he held would be treated as currency, not a warehouse claim on specific gold. Nortz v. United States, 1935. That is the pattern. A hedge becomes a regulated claim. And then a regulated claim becomes whatever the state says it is. To understand what Roosevelt actually shut down, you have to go back before the panic. Back to convertibility. The United States moved back towards specie payment with the Resumption Act of 1875, and redemption resumed in 1879. Later, the Gold Standard Act of 1900 locked the gold dollar into statute more explicitly. That mattered, because in that system, a dollar was not supposed to be a floating political promise. It was supposed to be redeemable money under legal discipline. Treasury policy, bank reserves, and public confidence all sat under that ceiling. U.S. Congress, Resumption Act 1875, Congressional Research Service, brief history of the gold standard in the United States, and private gold ownership sat inside that architecture. Not as decoration, not as nostalgia, as a private reserve. If you kept gold coin or certificates, you were holding a form of money that did not depend on a bank staying open tomorrow morning. You were holding a way to refuse counterparty risk, a way to leave the balance sheet. That is the detail modern retellings flatten into romance. It was not romance. It was option value. You could stay inside the credit system, or you could step outside it, and that distinction became lethal after 1929. Between 1930 and early 1933, bank failures spread through the country in successive waves. The fall 1931 crisis turned national. After Britain left gold on September 21, 1331, the FDIC's historical record notes that bank failures, deposits in failed banks, and currency held by the public all jumped sharply in that period. The Federal Reserve's own history of the March 1933 bank holiday describes a full national suspension of banking transactions to stop the collapse. FDIC, 1930, 1930-19. Federal Reserve history, bank holiday of 1933. So when Americans asked for gold or held on to it, the official language called that hoarding. But look at the mechanism. if your bank might close, if convertibility might fail, if deposits could be trapped behind a holiday, then gold was not a speculation on higher prices. It was an exit before the door locked, a defense against being forcibly converted from a hard claim into a managed paper claim. And once enough citizens try to make that move at the same time, the state confronts a brutal choice: honor the exit or close it. That is the real setup for April 1933. Not greed, not superstition, not irrational panic. A run for legal distance, distance from bank insolvency, distance from policy improvisation, distance from promises that could still change after you accepted them. And that is why private gold ownership had to be redefined before the monetary system could be rewritten. March 1933 is where the pressure becomes visible, not in theory, in sequence. On March 6th, Roosevelt declared a national bank holiday. Banks closed, payments froze, normal convertibility stopped while Washington decided what the new rules would be. Franklin D. Roosevelt, Proclamation 2039, March 6, 1933. That date matters because once the banks close, private gold stops being just a reserve asset. It becomes a competing answer to the state's emergency program, and the state understood that immediately. Under the Trading with the Enemy Act, as amended by the Emergency Banking Act of March 9, 1933, the executive branch gained broad power over gold transactions during the declared emergency. Congress did not simply stabilize banks, it widened the legal lane for direct control over monetary metal. U.S. Congress, Emergency Banking Act, 1933. Then came April 5. Executive Order 6102 ordered most persons and businesses in the United States to deliver gold coin, gold bullion, and gold certificates to the Federal Reserve or a member bank by May 1, 1933, with limited exemptions. The official settlement price was $20.67 per ounce. Violation exposed holders to fines up to $10,000, imprisonment up to 10 years, or both. Franklin D. Roosevelt, Executive Order 6102, 1933. That is the legal machine in plain language. You had a surrender window. You had an official price. You had criminal penalties if you refused. And notice what disappeared inside that machinery. Choice. Before the order, if you distrusted a bank, you could move into gold and hold it. After the order, your monetary defense had to be delivered back into the same national structure you were trying to hedge. That reversal is the real event. Not that the state wanted gold. States always want reserves in a crisis. It is that the state converted your defense into its recapitalization material. At $20.67 an ounce. Now put a person inside that structure. F. Eugene Nortz did not hold mining stock. He did not run a bullion operation. He held gold certificates issued by the United States. In January 1934, he surrendered them and accepted paper currency, but did so under protest because he wanted the gold value, not a paper substitute. When the case reached the Supreme Court, the court ruled against him. It said he could not claim the later revalued gold content through the certificates he had turned in. Nortz v. United States, 294 U.S. 317, 1935. That outcome tells you more than any speech. Nortz followed the legal process. He preserved the documentation. He sued. He still lost the thing that mattered. Not because he misunderstood the rule, because the rule had changed around him. And that is why confiscation is too small a word for what happened in 1933. Confiscation tells you something was taken. This was more precise. The state first made private monetary protection unlawful to keep. Then it made compulsory delivery look like lawful compliance. Then it treated the surrendered claim as something less than the holder thought he owned. That is how private property turns into emergency inventory. But even that was not the deepest break. Because metal was only one layer of defense. The other layer was contractual. Before 1933, Gold clauses were written into bonds, mortgages, and other long-term agreements to protect the creditor from currency debasement. They did not require bags of coin to change hands in the street. They required equivalent value. If the dollar was weakened, the debtor still owed payment measured against gold. That was the point. It was private language designed to survive public monetary drift. And that is the part most retellings leave out. The government did not just move against gold in your possession. It moved against gold in your paperwork. On June 5, 1933, Congress passed a joint resolution declaring that gold clauses in public and private contracts were against public policy, and that obligations could be discharged dollar for dollar in legal tender, not equivalent value, nominal dollars. Whatever the state now defined as legal payment, Joint Resolution of June 5, 1933. That sounds technical. It was not. It meant that if you had written a contract specifically to protect yourself from a broken currency, the protection could be voided after the fact. Read that again. After the fact. So the sequence becomes clearer. First, the exit asset is controlled. Then the fallback contract is neutralized. The system is not only taking reserves, it is closing alternate settlement language. Now put a name on that break. The Baltimore and Ohio Railroad had issued bonds containing a gold clause. George Norman, a bondholder, argued that repayment should honor that promise rather than the new paper-only rule in Norman v. Baltimore and Ohio Railroad Company. Decided on February 18, 1935, the Supreme Court upheld Congress's power to invalidate those clauses in private contracts. On the same day, in the gold clause cases more broadly, the court accepted that the government could override these protections in the name of monetary authority during the emergency. So, now look at the full structure. If you held the metal, they could compel delivery. If you held the contract, they could rewrite settlement. If you held dollars, they could manage the unit itself. That is not ordinary crisis management. That is jurisdictional expansion over every layer of monetary self-defense. And once that architecture is in place, the next step becomes possible. Repricing. Not while you still hold the hedge. After you lose it. Now the buried lead. The decisive transfer did not end with surrender. It matured with repricing. The Gold Reserve Act, signed on January 30th, 1934, transferred title to monetary gold held by the Federal Reserve Banks to the United States Treasury. Then, on January 31st, Roosevelt reduced the gold content of the dollar to 59.6% of its former weight. In practical terms, the official gold price moved from $20.67 to $35 an ounce. That was not a market gain available to the citizens who had already been forced out. It was a state-directed revaluation after centralization. And that changes the moral structure of the story, because once private holders had been compelled to deliver at the old statutory price, the upside from devaluation no longer belonged to them. It accrued to the sovereign balance sheet, not by accident, by sequence. The Federal Reserve's own historical summary is blunt about the mechanics. Title moved to the Treasury, and the new official price reduced the gold value of the dollar relative to the old standard. The government gained room to expand reserve assets and alter the monetary base under the new legal regime. This is the part many Americans never hear. They remember the order to surrender. They do not remember the repricing after exclusion. And that is the real forensic break. If you still owned the hedge when the unit was devalued, you could at least capture some protection. But the state solved that problem first. It removed the public from the hedge, then changed the unit, then kept the balance sheet benefit. That is not merely confiscation. It is controlled transfer through legal timing. First, your reserve asset is prohibited. Then your contract defense is voided. Then the unit is devalued after you cannot participate. So the question is no longer whether gold was taken. Of course it was. The deeper question is who got the revaluation. The answer is the Treasury. And once you see that, the episode stops looking like an emergency exception and starts looking like a template. In systemic stress, the state does not always begin by openly seizing wealth. Sometimes it starts by redefining lawful ownership, lawful settlement, and lawful benefit, until the thing that protected you is still real, but no longer yours in the form that matters. Say next for part 6-6. Next part 6-6 required word count 250. Fort Knox opened to receive gold in 1937. Today, the U.S. Mint says the depository holds 147,341,858. 38.2 fine troy ounces. That is the architectural endpoint of the 1933 to 1934 redesign. Reserve metal centralized under sovereign control. Behind a legal wall the public does not cross. U.S. Mint, Fort Knox Bullion Depository. And the modern parallel is not, they will take your gold again. That is too theatrical, too easy. The real parallel is narrower and more useful. When systems break, governments and regulators often begin by redefining which claims remain private, which become resolution material, and who is allowed to keep the hedge. In Cyprus, in 2013, uninsured deposits over 100,000 euros at Bank of Cyprus were converted in part into equity during the bail-in, while capital controls limited exit. European Stability Mechanism, Cyprus FAQ 2013. IMF Cyprus, Request for Arrangement 2013. Different asset, same logic. Your protection is real until the state decides it is part of the repair. So here is the survival protocol the forensic record gives you. Do not ask only whether an asset is valuable. Ask whether it remains yours under stress. Do not ask only whether a contract is legal. Ask whether it can still settle outside policy discretion. And do not confuse nominal ownership with usable control. Because in the end, every hedge faces the same test. Either it stays a private claim outside the failing system, or under pressure it becomes inventory inside it.